Okay, I think we're ready to start. So if you can please take your seats. So my name is Martina Polasek, and I'm very pleased to welcome you to this launch of a very exciting book. It's an article-by-article commentary on the 2022 ICSID Rules and Regulations, really freshly published. This is one of the first copies, and I was very fortunate to get one, so thank you very much, and for the copies that you donated to ICSID. We're very grateful for that. Now, it's a commentary that focuses on ICSID convention proceedings, so it goes through the arbitration rules, the revised arbitration rules, conciliation rules, institution rules, and administrative and financial regulations. But it also has some very interesting chapters about enforcement of ICSID awards, the interplay between ICSID and the investment court initiative, and also the history and future of ICSID. And we're delighted to have with us today a few of the authors from the stellar cast of contributors. They did a remarkable job just breaking down each of the provisions paragraph by paragraph. So it's very much like Schroyer's commentary of the ICSID Convention. It really goes through each provisions and has some really useful references to past practice and under the previous arbitration rules and how it is relevant or expected to change under the revised rules. So that's very helpful. Now, as you know, the revised ICSID rules came into force on July the 1st of this year. And this 900-page volume was published just 4 months after that, right? But I know for sure that you didn't start it when they were enacted. You started the work much earlier than that. And so for each working paper, you had to amend each of the chapters to account for the changes. So I imagine what you must have been going through. And I imagine also that the voting process must have been a nail-biter for some of you, right? We needed 2/3 of the votes of our membership to approve. And while we were confident that we will get that, you could never take that for granted. Now we ended up with 85% in favor. And there was no vote against, so that was a very good outcome. But I can imagine that you were just as relieved, happy, and excited that the rules were passed as we were. Yep. Now, today we will hear about the speaker's experience with the draft, with the commentary, and their thoughts on the amendments, with a particular focus on the chapters that some of you have contributed to. We will first hear from the two main editors, Dr. Richard Happ and Dr. Stephan Wilske, who have joined from Germany right on time. There was a snowstorm, so we were a bit worried, but they made it on time, fortunately. Richard is a partner with Lutz in Hamburg. He acts as counsel and arbitrator and is a board member of the German Arbitration Institute and currently the president of its arbitration council. And he's written a doctoral thesis on Article 26 of the Energy Charter Treaty and authored many papers on investment arbitration. And in the commentary, he has co-drafted the commentary on Chapter 4 of the arbitration rules concerning the conduct of proceedings, so first session, case management conference, and those type of provisions. Now, Stephan is a partner with Gleiss Lutz and also practices as counsel and arbitrator in international arbitration. He has law degrees from Germany, France, and the United States, and is admitted to the bar in Germany and New York. And he's also admitted to various U.S. federal courts, including the U.S. Supreme Court. Now, he has co-authored the chapter, or the commentary on the chapter on evidence.
Completely irrelevant.
Very relevant, very relevant. And that's chapter 5 of the ICSID Arbitration Rules. Now, after Richard's and Stephan's introductory remarks, we'll have a roundtable with other great speakers who have joined us today. We have next to Stephan, Alex Bedrosyan, who is an associate in the DC office of Hughes, Hubbard, and Reed, and is a member of the firm's International Arbitration Practice Group. His practice focuses on public international law and international arbitration, and he also represents clients in arbitration-related litigation in federal courts. And Alex has co-authored the commentary on Chapter 2 of the Arbitration Rules concerning the establishment of the tribunal, together with Jim Boykin, who is chair of Hughes Hubbard Investment Treaty Arbitration Group, and who is also here today in the audience. And next we have Susan Franck, who is a professor of law at American University, Washington College of Law, and is an expert in the field of international dispute settlement, investment law, and empirical analysis of international law. And she has a background in private practice and acts as an arbitrator and mediator in international commercial disputes. And we're all very grateful to her for all the empirical research that she has presented to us over the years, and which has been very also instructive and helpful in the ICSID Rule Amendment project. So thank you for that. And in the commentary, she has contributed with a paper on the once and future ICSID, with a unique insight into how the history has shaped the ICSID institution and into what it is today. So that's a very interesting one. And next we have Lindsay Gastrell, who is an independent arbitrator and senior counsel with Arbitration Chambers in New York. She's dual qualified in New York and England and Wales, and educated in both the civil law and common law traditions. And before joining Chambers, Lindsay represented clients in investor state and commercial arbitrations at Freshfields, and then served as legal counsel at ICSID. And I'm pleased to say that while Lindsay was at ICSID, she very much contributed to the amendment project. And all I can say is that we miss you in the implementation of that project, Lindsay, but I'm sure that you will contribute to the implementation as an arbitrator. Lindsay's piece in the commentary is a retrospective, really looking back at ICSID from the year 2052 and assessing how it developed from the year 2022. So it's sort of looking into the crystal ball. And finally, we also have Cedric Soule, who is counsel with King and Spalding's offices in New York. He is trained and qualified in both the common law and the civil law, and is trilingual in English, French, and Spanish. He acts as counsel in international arbitration and also has experience in ICSID annulment proceedings and with enforcement of awards in various jurisdictions in Europe and South America. And he has co-authored the commentary on the all-new ICSID expedited arbitration rules, and I very much look forward to his predictions about the use of those rules. And with that, I will hand over to Richard and Stephan, and I look forward to the discussion, including hearing about the next edition, which I hope will address the additional facility rules and the mediation rules and the fact-finding rules.
We give the publisher a call. Yeah.
If everyone here in the room and online buys a copy, that shouldn't be a problem.
And I would love to hear from the speakers about your favorite amendment or any new ICSID dispute resolution option that we now added. Is there one that you think will make an impactful difference to proceedings, and if so, why? So consider that question for the roundtable.
Time to review.
Yeah. So congratulations again on the book. I'm sure it will be very successful, and thank you for coming today.
Good evening, everyone. On behalf of the editors, it's a great honor for us to be here today, and we would like to thank ICSID, in particular Martina, for having invited us to come and present our book tonight. We expect the sales to skyrocket as of tonight. Wonderful Christmas gift. As you mentioned already, why do two grown-up people edit a book of 900 pages when it's not even secure that the rules will be issued at some point? With every book of this size, there is something like a story, how it came up, even something like a founding myth. The story of this book starts with the German national rounds of the Philipp Jessup International the National Moot Court competition in Germany in 2019. These rounds took place in the wonderful city of Hamburg, Richard's hometown, and we had been judges in the German national round. We had known each other already for various years at the time. And the real intellectual birthplace, that's a historical style restaurant in Hamburg's wonderful new opera house, the Elbphilharmonie, the new concert hall on the Elbe River. Richard and I, we were enjoying some drinks. Some people later on said they contained alcohol. I'm in full denial. We were teasing and mocking each other about public international law, contemporary philosophers, unforgotten artists, tragically overlooked rock operas, and finally talked about the definite challenge of those days, the issue of the ICSID Rules Revision Project. And there was a plan to do something together, Richard and me. And whenever Germans think about doing something together, in the old days they were building new machinery. Unfortunately, that is not so popular with the youths anymore. Or they got in trouble with their neighbors. That is, I'm quite happy, not so popular either. Or they write a thick book on either philosophy or the law. And such a law book is often called a commentary. And Richard, he confessed already he's a prolific writer. I'm not showing you my list of publications. Otherwise, my managing partner's asking me, and what are you doing else? We like the idea of a commentary. A commentary in the German legal tradition, that is a book which gives you guidance on each and every rule of a given code or a set of rules to make life easier for you and for the users. And it's always possible to hide behind the authority of such a commentary. I mean, it looks nice and impressive on the bookshelf, and it has exactly that function. Help the freshman who is first, help him or her explain what's different in ICSID arbitration compared to international commercial arbitration, but also help the seasoned ICSID practitioner who all of a sudden needs to deal with a situation not foreseen so far, and understand what the difference is to the 2006 rules. There's, of course, when two men write a thick book, that is already, yeah, you smile already, Frauke, you know what comes. There's always something self-serving. With men, it's always a little bit vanity-driven. And of course, we had the vain idea of that future generations of ICSID lawyers might refer to this commentary in their legal submissions in ICSID arbitrations. And if asked by partners, peers, or members of the arbitral tribunal, how did you come up with this crazy idea? They could say, well, that's all. I copied it from the Happ Wilske. The magic formula was a little bit taken from the Klimmer twins and explained by my most favorite English contemporary philosophers, creative tension. We live on it. Richard.
Yeah. When we started this project in March 2019, it was abundantly clear that we would not be able to do it alone. At that time, ICSID wanted to finalize the rules amendment project in 2020. So reviewing and commenting on a whole new set of rules in just 1 year, with, as he said, us being practicing laws at the same time, completely impossible for the two of us. There are thus a lot of people without whose support and input this project never would have succeeded. These are, besides our co-editors, the ICSID Secretariat, and our families, our authors. Our idea was to get the superstars, but knowing how busy superstars can be, to look, if possible, for a combination of superstar and rising star. When you now look at the combination of the various authors, we leave it to you to decide who the superstar is and who the rising star. Martina has already presented those which are here today. But, of course, when you deal with 38 authors in total, there are always developments, and sometimes particularly sad developments. One of our authors was Alvin Yeo of Wong Partnership in Singapore. He had authored, together with Svea and Co., Chapter 6 on special procedures, and unfortunately he passed away after having submitted the final version of the chapter on 30 July 2022. Alvin was, as I said, the co-founder of Wong, a leading Singaporean law firm and the youngest lawyer ever to be appointed as senior counsel in Singapore. He was a great lawyer and a role model for many. We kindly ask you to include him in your prayers. Alvin would have loved to celebrate the book launched, but was only able to complete the hard work without harvesting the fruit of his hard work. So I kindly ask you just to keep a minute of silence before we begin with the event as such. Thank you. May he rest in peace. Let's start the discussion. We have compiled a list of questions which we're going to ask our authors in that respect. Every panelist then is free to comment on the answers. And at the end of the discussion, everyone in the audience can also ask you questions. So, our dear authors, start your engines. Stephan will start with the questions.
We with Alexander. You are in charge of the comment fee for Rule 14. And as you know, under these new rules, in particular Rule 14, the parties and the arbitral tribunal will know now that a party to the dispute is receiving third-party funding. Does that fact affect the course of the dispute? And if yes, how?
Sure. Thank you, Stephan. Thank you, everyone. It's a pleasure to be with such esteemed co-authors and co-panelists. The answer is possibly. There are many implicit ways that disputing parties can attempt to invoke the fact of funding to their advantage. And I'll just put the caveat, just because one has an opportunity to advocate doesn't mean one necessarily should all the time. But the party that's not receiving third-party funding, the non-funded party, assuming it's a state, it may attempt to use the fact that the investor is receiving funding to bolster this narrative that the investor doesn't spend its own money and didn't make the investment itself, didn't make contributions if those are required under Article 25. And of course, this already happens now. The non-funded party may try to use the fact of funding to support an application for security for costs. On the other hand, the funded party may highlight may argue that it's seeking funding because it's impecunious, and the reason why it's impecunious is because of the horrible damage caused to it by the respondent. So kind of using the fact of funding to bolster its case on the merits. And also, it may try to create the impression that its claim is meritorious, because in order to find third-party funding, the third-party funders usually do some pretty robust due diligence on the strength of the claim. So if the claim is funded, the funded party might say, see, a funder consisting of esteemed smart lawyers thought this was a good claim, implicitly, not explicitly. And another area that is quantum, because funders usually, the typical business model is the funders have a priority right in any compensation that's paid to that's paid to the party that it's funding. So this affects settlement incentives, because what would have been a normal amount to satisfy the investor might not be a high enough settlement offer to satisfy the investor and the funder. And it might also affect the way the tribunal perceives the amount of damages claimed. Like, oh, this must be inflated because the investor has to satisfy the funder. Now, all of this collides with the fact that the stated purpose of Article 14, to disclose funding, was only to detect conflicts of interest between the funder and the members of the tribunal. So in theory, this narrow stated purpose should limit the inferences that the tribunal can or will draw from the fact that a party is receiving funding. But we'll see how it works in practice.
Please allow me one quick follow-up question, because you mentioned applications for... Sorry for that. One quick follow-up question. You mentioned the likeliness of applications for security for costs. Now my question to you, I mean, if someone receives third-party funding, does this not automatically trigger an application for security for costs? Would it not be malpractice if you don't do so?
Well, from the applicant's perspective, security for costs can be a way to get the case off the table automatically. So I think it's very likely that if there's any grounds to support an application, it will be made. And I think funding by itself, I think the commentaries have made clear, it's not by itself enough to grant security for costs, but funding plus something else might be enough.
Another question. Another question. We all know that currently there are a lot of theories and arguments going on how tribunals should be constituted, whether they are constituted all being appointed by a tribunal because party autonomy is a thing of the past, or whether you have an investment court. The new ICSID rules haven't really changed how to appoint the tribunal. Does that have any significance in your view? And if so, what is that?
Thank you, Richard. I think it does in the context of this debate that you mentioned. On the surface, it might be explained away. The fact that a lot of the rules, the very mechanical rules for how to appoint a tribunal, they didn't change from this rule to the 2006 rules. And that might be explained away as unimportant, but it does reflect a policy choice by the member states and by ICSID to keep party autonomy as the way to establish a tribunal. And this means that the responsibility to establish a tribunal, it remains on the parties and do all the ethical responsibilities inherent in establishing a tribunal. These ethical obligations include making sure that the tribunal is impartial, so maintaining the integrity of the proceedings. And in 2022, I think it could be said that there's an ethical obligation to consider establishing diverse tribunals, diversity broadly defined. And in these rules, we have a policy choice to issue paternalism and trust the parties and the parties' external lawyers to be the ones to fulfill these obligations and establish the tribunal.
Thanks. Does any one of our fellow panelists wish to comment on that?
Yeah, I have a question, Alex. The rule talks about if a non-party providing funding is a juridical person, which I assume is going to be the case in almost all cases, it says the notice shall include names of the persons and entities that own and control that juridical person. That's pretty vague. So how do you think that's going to be dealt with in practice?
Yeah, well, there are other rules and other parts of the ICSID Convention that define control. There's case law on this. Obviously, it's for jurisdictional purposes, not for funding, but I would imagine that the non-funded party will cite to any favorable case law for a broad definition, and the other party will cite to opposite case law.
Yeah.
In
Can I just stir the pot, because that's part of my job in life? We have some funders in the audience, and I was noticing that, for example, one of them has been very thoughtfully writing on costs in the past, and I was just struck by, of course, the job of a professor is always to play the devil's advocate. So the comment that you suggested was that funders may have incentives to have unreasonable settlement, right, built into their, essentially, their return on investment when they're deciding, do I fund, do I not fund, and somehow that has an implication. But I'm wondering, are we trying, with that conversation, are we putting all funders in one box when we actually may have different types of funders? We may have funders who are very careful about that and would not, in fact, do that to create a disincentive to settlement to get a, shall we say, a solid return on investment. And yet we may have cowboy third-party funders who may not have the same level of regulation. And so maybe we should kind of, when we're thinking about the interpretation of this rule and the impact of the new choices, think really carefully that not all third-party funders are created equal.
If I may, just a brief comment on that. I have very early experience with third-party funding in ICSID arbitration. And in my personal experience, I can say that third-party funders have sometimes a much more objective view on settlements than parties. Parties will look at cases and they sometimes feel the need to obtain a certain result, be it that they have promised that to their board or to their supervisory board or to their shareholders, while a third-party funder looks at money and whether this is objectively sensible or not. So I can, without going into details, disclose, I have witnessed third-party funders arguing to accept a settlement proposal where the party said no, with the result being that rather they should have accepted the settlement proposal. So I think it's not good to throw, how do you say in English, to throw everyone in one basket. There are third-party funders and other third-party funders, and you cannot judge all by the same rule or yardstick.
Can I?
Yes.
Yeah. I just wanted to come back to one thing about the Rule 14 requiring that you have to disclose the ownership and control of a third-party funder. I mean, I don't think we were thinking in terms of the jurisprudence of foreign control under, for parties, for real parties in the proceeding. And you really have to put it into the context of the purpose of the rule, which is to prevent conflicts of interest. So obviously, if you are a funder that's a publicly owned corporation with thousands of shareholders, you are not required to disclose every single shareholders. Really what states wanted here is to have the sort of the ultimate owner who may be the party of interest in the arbitration. So that was what the rule is targeting, really. And if you cannot disclose a particular owner or controller because of the corporate structure, you have but to indicate that to to us, to ICSID, and to the tribunal, and explain why that is not possible, and then take it from there.
I just wanted to add a bit complexity to the question to Alex, and I think you probably helped him now a little bit. I had a case with third-party funding under the old ICSID rules, and that was kind of a crowdfunding. I mean, the guy relied on family resources, even on minors. Everyone had to chip in. And I'm so happy that Rule 14 did not apply yet. I'm just wondering, now under the Rule 14, would I need to disclose every family member who throws in $2,000, $5,000, $10,000, the whole family? Would I need to throw that in? And I mean, is that, I mean, let's not talk about data protection, about the protection of minors. It was against an authoritarian state on top. I'm just wondering, I mean, this kind of narrow interest of conflicts. With a 14-year-old daughter who's more or less forced by daddy, you throw in some $5,000 from your savings to support Uncle XYZ, to run against the state of XYZ. So, answer please.
Well, and assuming all of these persons had their remuneration was dependent on the outcome of the case, to put it in the text of the rule.
Yeah, they get the money back plus, I don't know how many percent. I didn't even inquire.
I think there was some debate on this, that is it only entities or people who are engaged in the business of funding completely, or can it be others too? Because there are cases where a philanthropic organization funds a case and things like that. I think I'll have to dodge your question about whether all the family members have to be disclosed. I mean, obviously, if they're disclosed, and as you said, there are issues of protecting privacy, those could be dealt with, with confidentiality orders and things like that.
Well, I think Martina helped you a little bit with the purpose of the rule. It's not exposing a 14-year-old girl who was forced to chip in $2,000. Yeah. I hope that works.
But I think this shows how important it is to have a commentary also discusses the purpose of a rule.
Yeah.
And that we, of course, you cannot discuss every problem which might happen in practice. Before we turn to our colleagues on the table, let's discuss briefly those rules which are also completely new, and these are the expedited rules. Cedric, you're going to the table. What's your view? Will they ever be applied in practice?
I hope so. I think it's a great initiative from ICSID to and from the states to have included this, and I think so. The first thing, the obvious thing, is that both parties need to agree, so they can't be imposed so far. But I think that there will be situations where parties in council feel that depending on, if it's a case with not too many witnesses, not too many experts, where the timelines feel workable, that this is, the right kind of case to do it. I've been involved in cases opposite states where we've agreed, for example, to forgo document production. And, from the outside, you might think, ooh, no one would ever agree to forgo document production, you're going to lose an advantage. But there are situations where both parties feel that it makes sense in that context, right? So I'm certain that there will be cases where the parties will feel that it's appropriate to have page limits and shorter time limits for submissions. And those cases might be, like I said, cases where there are not very many witnesses, or there are not very many experts, or contract cases where there's an ICSID clause and it's a sort of very narrow breach of contract dispute or something like that.
Changing the topic slightly, do you believe, Cedric, that any features of the expedited arbitration rules will make their way into standard arbitrations, or does this remain something very ICSID specific?
So I certainly hope so. I'm a big fan of page limits, and I would hope, so page limits is a feature of the expedited rules. They are not a feature of the main rules, and I would hope that is something that you already see in main proceedings for post-hearing briefs, for example, where for some reason we all agree that page limits are okay for post-hearing briefs, but not for the main submissions. And I wonder whether that is not something that will become more standard. And that is a feature of the expedited rules that I would hope would make it into the standard rules, just like time limits for the issuance of an award was something that we only saw really in expedited rules, and now it's a feature of the of this, or the time limit. There's a, whatever it is, 8 months or something by which the tribunal has to say we're almost done, or we're done, or something like this, and that was not something that used to be in the main rules, and that is something that now is. So page limits is my bet.
Okay. Yeah. Susan. Back to the future or back to the past. William Faulkner once said, the past is not dead, it's not even past. What does this tell us about the history of ICSID? What can it teach us?
Well, I first wanted to thank you. You may not know the genesis of this, but Richard asked me to participate in the book in March for a 5-page commentary, which ended up being a much larger submission. I know, can you believe that? And basically, I was able then to do a massive deep dive into the history of ICSID at precisely the same time I was having a lot of personal disgust with TikTok and Twitter and all sorts of other modern methods of conveying information and disseminating knowledge. And it struck me that it's like ICSID needs a TikTok video to explain itself, so that people really do understand what's going on and how information that we have readily at our fingertips is just as vibrant today as it was then. So because I do think that we have a lot to learn about the past, because it tells us so much about our present and what I think the future is going to be teaching us, because we really will forget the past and then live at our peril. I believe that deeply, having done this deep dive where I learned a lot myself, things I didn't know, but also relearned things that were quite fundamental. And in terms of why I think that that's correct, like we make so many strategic, or our founding fathers, and dare I say, mothers, made strategic decisions about the past that will continue to affect us today, in 20 years, and in 40 years. And part of that is not just about the jurisdictional reach of the treaty, but also the structural divides that the rules in particular address. Now, I believe, and Martina can maybe correct me on this, that there may be a video of the Washington Arbitration Week event that was put on last week, or no, it was last month, what am I saying? And Meg Kinnear delivered the keynote address for the conference. And one of the things that she said, and I wrote this down so I could use it for today, is for dispute resolution, the core innovation of ICSID was, quote, not to veer into the substance of international investment law. That was the lesson that I relearned in history. And it wasn't just window dressing. There were snappy comments by Brokus. You could see repartee going between the delegates at various meetings. And it wasn't just the developed world making these comments. It was folks from the developing world being quite spicy and, dare I say, a little bit pushing back onto people, saying, no, it's this, no, it's this, what about this? And in an era where I have had personally, and this is probably my fault, a tendency to think of international law as top down, this was an opportunity to be in the weeds and see that it was organic, that it was vibrant, and wow, was there a lot of fighting going on about the meaning of not just jurisdiction, but the meaning of that substantive law that would be coming down the pike. So to think that that wasn't something that they thought about is wrong, right? And I think it's important then to go back and look at that history in the past through the lens of the past, rather than simply from the lens of TikTok and Twitter videos. Right? So I want to just encourage us all to kind of get back to the past, look at the primary authority, and don't forget what we've already had to learn from, so we don't have to recreate it. And I could go on about this forever, obviously, so I'll leave it at that.
Susan, I just had a flashback into the past, and I now also recall that you had a page limit of 5 pages. You failed badly with this 25 pages.
Failed miserably.
But frankly speaking, I'm very
Frankly
happy.
speaking?
I'm very glad that you did not comply with this requirement, because the book is worth its money simply for the 25 pages. Thank you for that. I'm normally not praising people for not listening to us. In your case, I make an exception.
Bless, thank you.
Susan, you said we had so much to learn. What was the most, when you then dove into the history of ICSID, what was the most surprising thing you learned?
God, there were actually so many. I mean, part of it, I'll just dovetail from my previous response about the pushback that I saw that was quite stark from members of the developing world. And I also want to flag something that Antonio Parra had said that I'd actually forgotten about or kind of hadn't fully kind of delved into. That even before the drafting started, there was a comment, let me see if I can make sure I've got it, from an Iranian delegate in 1961. So this is in Antonio Parra's book, where this gentleman, Ali Akbar Kozapour, I believe, who was the alternate executive director of the World Bank for Pakistan, Iran, Saudi Arabia, Sudan, he basically said that ICSID, and here's the quote, in practice might have a great deal of business, because ... Many governments might insert similar clauses, dispute resolution clauses, in their commercial treaties. People saw this then. We can't forget about it. Yes, Aaron Brokus is on the record, thanks to a delegate from India who was kind of slapping him around a little, about the number of cases that Brokus thought were going to be commercial cases governed by national law, not treaties. And he went on the record to say 90 to 95%, and then he really hammered in on it's 95%. The commercial cases that you think might be benefiting from the expedited rules, 95%, 95%. But we've got the exact opposite situation today, right? 5% are probably the commercial cases and 95% of the treaties. So the pushback that you would see, I think, from the delegates and the foresight, I think they were taking care of their territory, if you will. And I thought that that was really lovely to see. There was a snarky no, it wasn't snarky. It was a polite comment from a Chinese delegate who called investment treaties peculiar, right? Those sorts of things. I mean, they were very much aware of the challenges that the treaties were raising. And again, I loved Mr. Adhikar, who was the Indian delegate who really kind of slapped Brokus around in some of the conversations. But there was a reason for that. The second thing that I think is really important when I looked at the ICSID convention history was I did some data analysis because I am that kind of nerd. I mean, there was that conversation. And one of the things that I saw, like the convention was finished being drafted in 1967, and at the end of 1969, a couple years after, right? After that, less than 60 treaties were in force and effect. Less than 60. And instead, if you counted up the number of countries that were like, no, we're not even, on the hook for an investment treaty, it was over, I think it was 125, 130 different states and territories, depending upon how you define state at what period in history, right? So it was, of course, Brokus could go on the record saying 90, 95%, because there were less than 60 treaties in force and effect. And most of them were from Germany and Switzerland, right? But there were actually a couple of MENA treaties. So 2 Middle Eastern states had treaties together at the same time, right? So it was really interesting. And the countries that were actually most active in the debates were the ones that had signed up to the treaties in the first place. So they knew the territory that they were guarding. So it's like those kinds of lessons. They understood what was at stake, and people were trying to be careful. I'm glad to see that. And I was glad to also be told by Antonio Parra that I didn't know. If you look at the history of ICSID, right, and this is kind of the optics of what ICSID convention history is, ICSID rules are, and I'll kind of end with this because it's about the founding mothers. There's basically a picture of Meg Kinnear, stenographers, and I thought that was it. But one of the women who was in the history, in the travaux, her name was Ms. Brune, who represented certain Nordic countries. Antonio was kind enough to remind me that that is Alice Brune, who was executive director of the World Bank for 2 years in the 1960s. Women had a role here at the World Bank, but we forget that. And in fact, I was able to find the picture in the book and I actually took a highlighter and I said, is this person who's sitting in the corner is wearing a suit and kind of looks like what one might think of as gender male in the 1960s, is that Alice? And he said, yes, as a matter of fact, that is. So I have to say, I have to correct something in my tome that there was in fact another woman in the book, and that was Alice Brune. We have been there. Females have been there, but we just have to make sure that the current generation understands that as well. Sorry, and my rant is now over.
For the second edition, we have already a correction. It's females plural. Okay. Comments?
Yeah, do you mind if I say something? Thanks. Susan, I really appreciated your contribution, in particular the thing that you highlighted, because I think we see a lot even in substantive submissions where on jurisdictional issues where parties sort of focus on this idea that the ICSID Convention was drafted and came about before there were investment treaties, that investment treaties had never been thought of before, that it was not on the mind. And like you say, there were few, and the prediction, at least, the marketing was that it wouldn't be huge. That wouldn't be a huge percentage of cases. But the fact is that they were considering them, and that they had been in the consciousness during those discussions at the World Bank. And I think that's really important.
And I think it's also important then the pushback that Brokers gave to that when people did say that that's of concern. And he was very clear. He said, if you don't want international law to govern your disputes, don't put it in. Sure. And it was like brilliantly handled. And that's why I so enjoyed, and this is why I say thank you for inviting me to write 5 pages, because the landscape that I was able to uncover was just so rich. And we all owe a debt of gratitude to ICSID for putting those materials on the web and available for free.
I think we are all very glad that we asked you to do something impossible. And that what we got was something possible. Isn't there even a Rolling Stones song? Sometimes you don't... Exactly, but what you get is what you need. Yeah.
Yeah.
Okay, we stay in the past, but we look at the past from a different angle. Lindsay, Gastrell, a look back from the future. I mean, that is your topic. And you look back to the past from a 2052 ICSID conference. And I mean, with this perspective, what do you see as the more important rule changes from the perspective of the newer generation of arbitrators?
Sure. So maybe I start with something that Susan started with as well, which is that, and this is something that I talked about in the essay, exactly what Meg started with. The ICSID rules are procedural, and that's it. They will no ICSID amendment project is ever going to affect the substance of international investment protection. And in addition to that, the ICSID amendment project did not touch the ICSID convention. And so some things that people will associate with policy decisions that the Secretariat or that the member states made in this process may very well just be that they were required by the ICSID convention itself. So there's only so much leeway that ICSID has when making amendments, and so I think it's important to sort of manage expectations. But if you look at what ICSID itself says are the goals of the amendments, it's important. They're really important, even if they don't go to substance. So what was ICSID trying to do? I was going to say we, but what was ICSID trying to do? What were the member states trying to do? They were trying to modernize the rules. These are the stated objectives: to modernize them, simplify them, to leverage technology, and to reduce the environmental footprint. Right? We're not talking about the substance of an FET standard or intra-EU BITs, right? It's a very specific thing. But that is what ICSID is good at. That is what, in particular, the Secretariat is good at. It's procedure. And so when you get the expertise of a group like the ICSID Secretariat looking into these things and working with the member states to come to a new set of rules, I think that effort is something we should all applaud. And so I'm going to then turn maybe to the second part of your question about the new generation of arbitrators and what the rules maybe hold from that perspective. And this also might go to Martina's question about favorite rules as well, but let me try. I think one thing that the new rules help with is something that we see, a trend towards more proactive case management by arbitrators, right? This is a trend we're seeing. And there is a perception that for too long, arbitrators were willing to simply apply cookie cutter rules to every single case, no matter how different the circumstances might be, too willing to allow parties to engage in dilatory tactics, and too slow to respond to procedural skirmishes that then escalate, these kind of things. So, and there's also a perception, or at least I have the perception, that the new generation, the younger arbitrators, are more willing and maybe even perhaps more capable of looking for willing to apply new procedural methods that are tailored to the circumstances of a specific case. And what I see in the rules is I see many examples that can help in that regard. And one of them is quite simple, but it's just requiring that there's an additional case management conference after the first session, sometime through the proceeding. And of course, we have no idea what tribunals are going to do with this, right? We haven't seen it yet, but it is such an excellent opportunity. This is a time for arbitrators to get involved, maybe even in the substance, but in particular in the procedure, to check to make sure that the case is on track. And you know what? Maybe even change tracks if that's necessary. And so I'm very excited to see how tribunals make use of this. The other thing this is my favorite rule, which is the express provision, or basically the rules say, tribunals, you can issue interim cost decisions. And of course that power was always there, but I think it's important to have the express recognition of that because it is such a powerful procedural tool, and I think it's been kind of woefully underused in certain circumstances. So that's another one that I will be watching. Also, if I have another minute, I think one thing, of course, that the newer generation of arbitrators is concerned with is the pool of arbitrators, and will we see, do the rules, could they possibly have any effect on broadening the pool of ICSID arbitrators? And I have had this discussion with a number of people, and there are some who believe that, with really robust disclosure requirements and time limits for awards, you may very well have very busy arbitrators who are less willing to take as many cases, therefore leaving room for other. I don't know. That's a psychology question that I can't really answer. I'm not sure if that effect will happen. But there are other provisions, and one of my favorites is, I think it's Rule 17, which allows the parties to ask the Secretary General for assistance with appointments. And again, this is something, that service was always there. You could always ask the SG for assistance. But again, by expressly recognizing that, by reminding the parties that that's there, I think it's important. Why? Because when the Secretary General assists with appointments, she's not restricted to the ICSID panel of arbitrators. She also has a really good eye on the market and may be able to propose candidates, very qualified candidates that wouldn't otherwise be on the party's radar. So those are just some of the provision I think are probably really important.
Lindsay, please allow me 2 follow-up questions.
Sure.
You made me hope a little bit when you said new generation, and I mean kind of the beginning of new rules. I was recently in a case management conference, and I heard too often standard practice. There was one feature which was not even in the rule, and it made no sense. But I heard much too often, this is standard practice, we always do it this way. Do you think it's now easier for us to fence off this kind of old nonsense from the past and saying that might or might not have been standard practice, but the time starts anew?
You can make that argument. We'll see. We'll see if it works. No, but I do think a sort of reset. If you're talking about a new rule or a rule that's been significantly changed, then sure, that's something to do. This, I think, there's an element of. I don't want to say laziness, but there's an element of inertia in when we're deciding on procedural issues, and you'll see that come up. ICSID cases, commercial cases, all the time. The accepted practice is this, and if the accepted practice is not correct or is not appropriate in those circumstances, then, can you do?
Okay. And I have the power of the mic at this point, and I abuse it. Your Rule 17, assistance of the Secretary General with appointment. Now, a very conservative point of view, which I've heard more often in the past, and at some point I even followed it. This gives a blank check to the institution to come up with all kind of policy issues. I want to have a person who combines 6, 8, 10 diversity features in him itself, and at some point you forget about the ability to manage this case. Please give me comfort that this will not be the case.
I can give you 100% comfort that that's not the case, because when that would be the case? That would be the case if there were no qualified candidates that didn't also have the elements of diversity that you're describing. Luckily for us, we are in 2022, and we are in a world where women and a range of diverse arbitrators from all over the world. We are in an international, it's beautiful. We are practicing international law in an international forum. There are so many possible candidates out there, and I think that the first thing that an institution cares about is qualification and ability, because it looks really bad. I know from working in an institution, it looks really bad if you mess that up. But then after that, there are other elements that can be taken into consideration. And I think what we've heard already, is that there might be an ethical obligation to do so.
Lindsay, you just said that we are in 2022. Now, the piece in the book looks at the rules revision from the 2052 perspective. Now, what are your thoughts how the new rules will play into the future of ICSID?
So that sort of goes back to what I was saying before about the what we can expect from the rules and what the goals of the rules are. Some of what happens to ICSID going forward will not be defined by the rule amendments or ICSID rules themselves. They will be defined by external decisions in particular, of states. And that's always been the case. That's been the case since Susan, from the very beginning. That is how it is. The sort of rise of investment treaties is a perfect example of how ICSID's future, starting from then, was shaped by something that ICSID itself, as an institution, had nothing to do with. But like I said, that doesn't make the goals that ICSID is trying to reach with these amendments any less important. And one of them, it's very, very important that, and I know personally from working at ICSID, how much the Secretariat works to control the cost and time of proceedings. It's a key thing, and it's a challenge. It's not just faced at ICSID, right? We face it also in commercial arbitration. I have a case right now in a commercial case where one party produced more than 1 million documents to another party, more than 1 million. And it's very difficult to speed things up in a world of complexity like the one that we live in, where maybe 1 million documents were actually, maybe, I don't know, maybe they actually needed to be produced in response to an order. So we're all dealing with this crisis of complexity and what can be done. And obviously we mentioned the time limits for awards. It's an important step, for sure. I think, though, and this is again going back to the Secretariat, I think that the most promising asset that ICSID has is the Secretariat itself, because you have these really skilled practitioners with a lot of experience who can keep cases on track, sort of observe, always looking for ways to improve efficiency, and getting arbitrators to speed up when they're not doing their job. So it's an important thing.
And now some slight deviation from the rules. While the panel was underway, we noted that one of our authors made it, and initially it was unclear whether she could come. That's why she was not the official panelist. Anastasia Ogales sits over there. She entered a couple of minutes ago. She's an independent legal counsel with a long-time big law firm experience. And she had authored, together with Tatjana Mineva and Baji Vazani, Chapter 1, the general provisions which, as we all might agree, are of a fundamental importance for any proceeding, but sometimes essential to understand. Given that time has already progressed, we nevertheless would like to ask one question to Stephan, will you?
Yes. Great for you to be here. Part of the consultation process for the rules amendment took place during COVID-19 pandemic. Now, has the pandemic affected any of the rules or their content? And if yes, please describe.
Thank you very much for the opportunity to speak. Sorry for my tardiness. We were talking about the future just a minute ago. So the future seemed to be in the future before the pandemic, but actually it's here, it seems like. I'm interested in arbitration technology, and one of the most exciting parts about the new edition of the rules was the introduction of the electronic filings and mention of the remote hearings in the arbitration rules themselves. So I attribute that rapid adoption of technology globally, but also in the ICSID context, to the pandemic. Obviously, the pandemic expedited that adoption. So we do see that the rules now explicitly allow the tribunal and the parties to conduct the first session and the hearing in person or remotely. And remotely part is actually up to the tribunal. So if the parties agree not to have a proceeding or a hearing in a remote format, then the tribunal may not decide to do so. But if there is no agreement, we still may have a remote hearing in the future. This has been debated actually during the pandemic. We've seen cases, in particular in the Vodafone case, where even a possibility or the right to have a hearing remotely was questioned, was challenged. So now it seems like this has been decided, and if in the past it was a challenge possibility, in the future we will have more hearings that are remote. In fact, during the pandemic, as you may know, ICSID conducted, administered most of its cases remotely. In 2020, 2021, actually all sessions and all hearings were remote. We may see more hybrid hearings in the future as opposed to purely remote hearings. During the Washington Arbitration Week, McInerney actually mentioned that parties more and more request to provide a remote connection to their teams scattered around the world, even if the hearing itself is conducted in person, but they do want to have connection for their team. So we may see hybrid hearings more in the future. My wonder and my question, also in the context of the new obligation to conduct the proceedings in a cost-efficient and expeditious manner, whether in light of this trend to have remote hearings, we may require from ourselves, from lawyers, from counsel, from parties, and arbitrators, a duty of competency in the relevant technologies. We do see that some of these duties of competence in the relevant technologies are adopted at the national level. Right, in the US jurisdictions, we have 40 states that now require it as an ethical duty. So my question is whether we will require disclosures from the arbitrators on how they can deal with the arbitration technologies that is related to teleconferencing, remote hearings, as well as maybe also annotation technology, because the new rule on electronic filings obviously explicitly requires us to file pleadings in electronic format, but implicitly also encourages us to review the submissions in electronic format. Obviously, that is very good for the environment. That is also a cost-effective measure. Yes, my question, I guess, is open-ended. We can discuss during the break or during Q&A. But this is something that I have been pondering about myself. Thank you.
Anastasia, thank you. I personally very much appreciate that you put the focus on technology. I had some in this room right now, a famous and some might say infamous case where a state challenged the whole tribunal because it had ordered a virtual hearing. And it's good that this is no longer possible. Now, your question I'd like to put to our fellow panelists. Do you want to answer that question? Do you have comments on what Anastasia just said on the duty of competency? Do we all need 360-degree virtual cameras? Backup Wi-Fi connections? Anyone wishing to?
I'm happy to start it off. I think it's an excellent question, and I'm definitely in favor of disclosures for competency, especially on the annotation, the electronic annotation thing, because I think that's the future, and I don't know that the arbitrators we appoint are there yet. I don't agree with the 360 virtual cameras, though, because I think hearings, I'm not a fan of virtual hearings, so I don't know that we want 360 virtual cameras, but certainly requiring arbitrators to confirm that they can handle, the different sort of technological issues you highlighted would be great. Would be a great innovation.
Just on the annotation, one thing I would say is that that would be great, but I'm not even sure if it's necessary because the move is so powerful right now toward that. And one thing that you see often is a little peer pressure among the members of the tribunal as well. So if you have two arbitrators who've decided to get everything electronically, some arbitrators will still, who really prefer paper and have, that's the way they work, maybe they will still demand that, but a lot of times I think you'll see some flexibility there, maybe just getting only the pleadings and the witness statements, but everything else electronically, that kind of thing. So hopefully.
I think that there's two elements to this, and one of them is what is competency. Competency is not being able to use a specific technology. It's having the ability to adapt to evolving circumstances. And I say this as someone who not just teaches legal ethics, but who is slightly obsessed with technology herself. So to the extent that what we would want in terms of an arbitrator is someone who is fluid and able and willing to adapt. It's the adaptability and the willingness to learn a new set of protocols that's far more important than anything. So when I think of competency, that's fine. But then in the arbitration marketplace, even if it isn't required under, for example, Model Rule 1.1 in the U.S. Model Ethics Rules is what requires your duty of competency, and the comments from the American Bar Association talk about that must include technological capacity. If you're a state that's adopted that, then you're good to go, but it's not that I have to have a 360 camera on my desk. No, it is that I have to have the willingness to learn how to work with whatever hearing format is required as a matter of law and what works with my co-panelists and the counsel and the parties. So I understand that you were setting up a straw person for me to knock down, Richard, so that is exactly what I'm happy to do. But number two, I think that there's also an element when we're thinking about technology is that don't assume that because someone is older, they're not an absolute technophile versus younger being a technophile. I'm looking at some of the data that I collected from ICSID now, and people's self-reporting of how they view their own mastery of technology. And it is surprising, irrespective of age, even people in their like 30s and 20s are not necessarily identifying themselves as technology masters, right? So this is something to kind of keep in mind. It is not an age-based issue. I think it is a propensity, are you willing to engage with something new type issue? And those are the kinds of questions for the new arbitrators. Hopefully one might be able to tease out through a conversational process.
Alex, what's your view?
Sure. I'll just add that as I was talking to some colleagues before, with virtual hearings, there's already the issue of where the parties are from different time zones. The hearing days get so compressed because one side is very early, the other side is too late. So it just reinforces the need that for maximum efficiency. So I would be very much in favor of that being included in the arbitrator declaration. But on that point, I want to say, if we're going to talk about our favorite rule amendment, the arbitrator declaration, the amendment, it was also amended, and it's implicitly incorporated through Rule 19, and it requires the arbitrators to show their availability for 24 years, even supplying calendars.
24 years?
Sorry, 24 months.
At least.
Thank you.
I had a moment.
Yeah, if
Well,
it's,
some arbitrations take a bit longer.
yeah, if it's a very complicated case. So I think that's critical not only for an expeditious proceeding, but it really gives comfort that the arbitrators have the mental energy and time to really consider all of the issues you put before them.
So I'm the voice of the ignorant, the incompetent, and the elderly arbitrator, and I'm the voice of diversity. I mean, you want to shut off a whole generation of arbitrators who, of course, depend on their assistants, who are not technology nerds sitting in a US law firm, who sit somewhere else where you have sometimes a bit difficulties with the internet. The 360-degree camera, that's a myth in any way. I've done that once, and then, of course, there were technical issues, and there were all kind of people, or hands and feet and whatever, but this is 1,000 miles away. Do you want to interrupt now at the hearing? No way, let's go forward. I mean, it's a blow to diversity. I mean, and it's hypocrisy on top. I mean, if you look at who is appointed, I mean, it's still a little bit the elderly man. UCOS, for example, was for me, I mean, really, I mean, hypocrisy as good as it could be. You have 3 arbitrators with a combined age of 268. I'm exaggerating only slightly. And then 75% was written by the assistant. My only question is who wrote the other 25%? And I mean, you cannot, I mean, the duty of competence, I mean, yes, as an elderly arbitrator, I ask my assistant, fill this out for me. I mean, the question is, I mean, where do we end up with? Do we only want to have the 25-year-old technology geeks who know everything about cameras and technology, etc.? And do we want to cut off people who are from countries where you don't have the latest technology? And I mean, that is something we should be careful about if we now proclaim duty of competence and we all feel competent. I feel sometimes so idiotic incompetent when I hear younger people, and I have not reached the 85 yet, despite my looks.
Well, as a concluding remark then on this topic, I would go with Susan and say we don't need really the duty of competence. We need to have some kind of willingness to learn. Being a partner in the arbitration department, that means for all of us who work as counsel, be willing to listen to what your younger associates tell you and accept that sometimes if they explain something to you which you don't understand, it might nevertheless be correct. And also as counsel, a duty of competency, all of this wonderful technology, let's use it not to make life for arbitrators more difficult by submitting more documents, but making it easier, if possible. So as lawyers, we should use it in a way which makes life easier, because I'm married to a judge and hear every evening how stupid lawyers can be in making life difficult for her. So we all still need to answer Martina's question. What is the most important rules amendment in our view? As editors, we reserve the right of the last word. I think Lindsay already gave her vote. Cedric, what about you? What's your favorite amendment?
So I think my favorite amendment would be, which I hope is an amendment, Rule 12.2, which is that if the tribunal cannot comply with an applicable time limit, shall advise the parties of the special circumstances justifying the delay in the date when it anticipates rendering the order, decision, or award. I think it just provides more accountability for the tribunal and something the users, I think, really, really wanted, and I think it's a great amendment.
Susan?
I have so many. I feel like you're asking me to make Susan's choice instead of Sophie's choice, but I will give it a shot. The mediation facility. This is something, as Franck knows, that I've been working on for over 10 years, trying to encourage the international arbitration community to think holistically about dispute settlement, such that mediation can and should be part of the solution. It is not the end. It is actually just yet another tool, a potentially, guess what, money-making tool to increase client satisfaction and demonstrate rule of law. Wouldn't that be a nice thing for everyone in international dispute settlement? But I think Gonzalo has left us, but one of the, oh, there, thank you very much. You know where I'm headed with this. I think you might. In connection with the ICSID data that I've been looking at, one of the things that I asked people was, have you been involved as a mediator in disputes? And one of the most surprising things to me is seeing the number of international arbitration specialists who've been acting as mediators in massive disputes. People self-reflecting that they've been doing this and this and this. And if that's the case, there must be a lot out there that's happening that we're just not talking about. And this is why the other day, Gonzalo reminded me of the movie Encanto and the song, I'm not singing this time, the song,
Please.
what?
Please.
Oh no, oh, we don't talk about Bruno, no. We don't talk about mediation. I can't believe you made me do it. We don't talk about mediation, but it's happening. It's all around us. And the real trick is to understand how can the mediation rules be used effectively and strategically. We need to think about building capacity for lawyers so that you can understand the value add to the client, to think what different types of models of mediation are you using it for? Is it for a big problem? Is it for a little problem? Do you want it to be a brainstorming session? Do you need more of an expert determination on kind of a thumb on the scale? That's the beauty and the creativity of the mediation facility that ICSID has created. It's created basically guardrails to guide the process so the clients can make it what they wish it to be. And if it does not work, so be it. That is the point. But it has to come along with, and this is, I guess, for your volume 2 that was asked for in 4 months, is for Franck, to maybe, I don't know, not sleep ever again, and to help us train a cadre of investment mediators for the future and investment mediation counsel who can think strategically about how to use the flexibility and forward-looking nature of the process to solve small problems to get good results.
Thanks. Alex?
Sure. I mentioned already Rule 19 that implicitly incorporates the new requirement for arbitrator availability. I'll just say one thing in closing. Susan and Lindsay talked before about history and how wonderful it is that the history is public of ICSID. I just want to reiterate how rich those volumes are and how adaptable they've proven to be. You mentioned that there was an awareness of investment treaties. Mr. Broach also talked a lot about other forms of consent where there's no privity between the parties, like unilateral declarations, investment laws. And every time you read those books, you'll find something that's applicable even to today. Like there's even a line in there about an arbitration clause that gives one party the right to unilaterally remove remove the consent. It's very relevant to these denial of benefits issues that come up. So to the extent anyone has free time after reading our book, I really suggest to go back and read the negotiations for the ICSID convention.
And can I also flag, and I don't know how they did it, but some of it is PDF searchable, not all of it, right? But the kind of search and find function is there for some key terms, but not all. And so the one thing is just take it with a small grain of salt, because if there's a typo and words are flipped or something, you might not find your keyword. So be a little bit creative in your search terms, but you might still be able to find it. And it's that massive set of material that ICSID has made so easy for us to find what we need. It's quite cool.
Yeah. Before Stephan concludes, I'll throw in my 2 cents of what it's worth. My favorite amendment is something which is no longer there, and that is the requirement to close the proceedings before the award can be rendered. In my very personal experience, the time or whenever proceedings will be closed has been completely obscure and unclear, and very likely a week or so before the award will be sent to the parties. And that is a serious problem, because we as counsel have clients, and clients at the latest after the hearing say, okay, I need to report to my board. Those clients are general counsel usually. When will there be an award? And so far the answer usually has been, we are not quite sure. Usually they close and then they have a time limit running. Okay, when will they close? No clue. No clue is not an answer which a general counsel likes to hear, because he has to report it to his board, and the board will say, how can they have no clue? They are so bloody expensive. This has now been changed. It no longer exists, and Rule 58 at least says that there are time limits when the award should be rendered. Of course, these can be extended, but this is something with which everyone can work. You'll at least have a likely time limit, which makes it much easier to explain to clients that this whole procedure is predictable and that there's a calendar, and if the tribunal says, I can't manage it, I need more time, well, other tribunals, ICC, for example, and other rules do it the same way. This is something they're used to. So this is, in my view, one of the most important amendments ever made, because it makes ICSID proceedings for users much more calculable. Stephan.
I mean, Rule 58 is, of course, external counsel's darling. When Martina said 85% of the states were in favor of the rules revision, no one voted against it, I thought, what a miracle. If I just look at what happens to the Energy Charter Treaty, this is something I consider to be not rational and destructive. And in light of this experience, I mean, for me, the biggest success is that the rules revision project was possible at all. I'm not in love with each and any new rule, but in general, I think that the system by itself could prevail, despite the mysterious multilateral investment court lurking out since the 70s or 80s and continuing it, that the system could still prevail, got a positive vote. I'm not sure whether this would be possible next year or in a month's time. I mean, again, it's frustrating if you look at the Energy Charter Treaty. And so again, for me, the biggest success was it was possible.
Well, thank you very much for these comments. We look forward to you using the new rules and look forward to your feedback about how they apply in practice. You know, if there's anything that you think needs improvement, do come to us and let us know. But in the meantime, I want to thank you all for coming. Congratulations again on the book. And also thank you to the online audience today. So, yeah, we'll have a cocktail together in the lobby. And thank you again.
And virtual cocktails for those participating remotely.